these other departments, those that are not only from SIU, because obviously you would have good people in municipalities and government departments, directors that would say, so and so have done wrong, let me take this to SARS, then obviously it's transferred to you to prosecute. Do you have any system to ensure that in the statistics that you do, you take into account those cases as well? And the statistics as well that you would have done of the cases in terms of the delay, in terms of what usually contribute to the delay of cases. Can Chair, if possible, if there isn't anything that is hindering us from getting that statistics, can we receive it so that we can be able to go through it? And lastly, Chair, I must just state that it really worries me that the DPCI would award, because I believe that these service providers to provide them with such things such as forensic accounting and so on to people that they would have not vetted. Why I'm saying that? If tomorrow I am a minister, it tells you that I have a proper network. Now, if we are going to add, if a case involves me, I'm just making an example, involves me, it means I have a big team that is behind me, that is trying to help me sort out that. Now, if you are going to appoint a service provider to come and perform particular forensic in maybe whether or accounting services for you without vetting them, what happens if one of those people is actually a close friend of mine? You know? And unfortunately, you can only perhaps find out when you get to court. You know, when lawyers start arguing and then you start finding out that the person that assisted you in doing this investigation is my friend. What then happens? So it really worries me, Chair. As well as the integrity of the investigation, it puts it into question. Thank you.
Yeah, like the Chair finding out his cousin is in the room. That sort of thing. And having to make a quick declaration on the spot. Can we start with Honorable Gupta's questions? Thank you. Over to you, Advocate Patwe.
Chair, I'm going to first hand over to Advocate Johnson, the head of IDAC, to deal with those questions, and then I'll sweep up. Thank you.
Honorable Chair, honorable members, and to colleagues from the SIU and the sister agency, the DPCI. Honorable Ndate Kubeka, you raised some issues that do pertain to IDAC, but then some of the general questions that have an investigative component to the DPCI also relate to ourselves, Chair, and I seek to perhaps be given an opportunity to deal with those. So, Honorable Kubeka, on the issue of IDAC only having 4 state capture cases in court, I thought I would clarify the SIU referred 10 matters to IDAC. Of those 10, 3 are in court, 7 under investigation. But if you take the state capture cases, IDAC currently has 37 state capture cases on the roll, plus 13 other corruption matters on the roll, bringing the total to 50 criminal matters on the court roll. I just thought I would clarify those. And I do take the point, Honorable Chair and members, that oftentimes matters seem to have failed. Unfortunately, we have had this discussion as well internally, is that there are certain things that we do not come out and say, as was the case in the New Lane matter. Part of our ethics and profession means we run process, and in the end, the process must speak for itself. And so you would not have found the NPA going out and making any negative comments, per se, about the presiding officer in the matter. You take the matter on appeal, it gets dealt with. So similarly, if you take the Gupta extradition, for example, and yes, we are criticized for having failed that extradition. And we didn't fail the extradition. When the UAE decided not to extradite the Guptas, Chair and honorable members, we wrote to them. We have to follow a process. 12 note verbals later, we still do not have any response from the UAE about why the extradition failed. Safe to say that they have asked us to resubmit. Now, how do you resubmit when you've submitted a full set of papers, properly checked, even by themselves? So it does put you in somewhat of a predicament. Do you now send these papers for it to be a so-called failed attempt again? We have now, however, taken a decision to submit new applications with additional matters. The country also cannot sit and wait while the NPA, unfortunately, has to follow a legal process. So having taken that into account, the public interest and the interest of justice, we will submit new applications, but not just for the matters that we had applied for, which was Estina and New Lane. We are going to apply for extraditions in relation to other state capture matters. And I just want to be clear about...
Sorry, may I ask, because I think, for context, has there been any other criminal prosecution, and this might be for Advocate Mzinyati and you as well, because it's not, this is a general question, where you've had to extradite, to have somebody extradited from the UAE? Is it generally difficult in the manner that it has been, or there is basically there's an exception here? That's what I'm trying to establish, if you know.
I can indicate, Chair, it's generally difficult, and not just for South Africa. So when we engage on such matters, and especially matters where we have foreign jurisdictions, we actually do engage with some of our international counterparts, and from the UK to the US and other jurisdictions, it has been a challenge getting extraditions from the UAE. So we've tried to do lessons learned, look at the best practices, and unfortunately, that is where we are. And then to indicate, for example, on the cocoa matter, I just have to be very clear. At no stage did the state parade Mr. Coco. Yes, there would have been pictures of Mr. Coco, but Mr. Coco appeared in a public court, and the media is allowed in court. And it has never been our modus, nor will it be. And if it was seen that way, it is unfortunate. But he was not singled out, Chair. So Mr. Coco, together with a host of other individuals, was arrested as part of a matter. We do not single out any individual. We have to follow the evidence. And what we put an accused, and not just him, what we do put an accused before court on are allegations. Their guilt and or not must still be determined by a court of law. And so we have to follow the evidence. We do not follow profile, and it becomes extremely important for the people of our republic to understand that we make allegations, they appear on a formal charge sheet, they appear in an open court, entitled to legal representation, and a court process is then run. We did allude to this, Chair, that we did have challenges in that matter, and there are legal processes with regards to the presiding officer that are being dealt with by the Magistrates Commission and the Legal Professions Council. And because they currently sub judice, I cannot allude to what is actually happening. In terms of potential for political interference, and they pick certain cases because they are influenced, I will say adamantly and vehemently, absolutely not. Not in the IDAC space. No one has tried to interfere. And I dare them to interfere because ours is an oath and an independence that's guarded by the Constitution, but by integrity of self and the institution. But what I'm alive to is one cannot say there would never be an attempt. If anyone has evidence, it should be brought to the fore, because it is important that we are seen to be able to do our work without fear, favor, or prejudice, Chair. I wanted to deal with this aspect that was raised with the DPCI, Honorable Kubeka, but because it might also relate to our space, on how do they secure investigations where services are outsourced. So in the main, I think together with the DPCI, one of the aspects where you find outsourcing would be the forensic investigations and digital forensics. In IDAC, they sign a Section 41.6 non-disclosure, which is Section 41.6 of the NPA Act, Chair. In fact, every single project and or teams meeting or meeting of the teams, when it takes place, the attendance register has on the right-hand side a reminder of the non-disclosure, and that details of that meeting and every meeting to follow do not get discussed or disclosed. I am aware that the supply chain management process of the NPA, they do run a risk profile. They do give us a heads up if there might be something we have missed, and we are asked to go back and relook at a different service provider. Perhaps in addition to indicate that in the IDAC space, we do have matters relating to state security, and the entity that actually looks at those matters were top secret cleared by state security themselves, just for purposes of finalizing that gap. And then the last thing, Honorable Ndate Kubeka, was on the Neotel liquid telecoms. Just to be clear that the corruption we are looking at relates to Neotel. Liquid telecoms unfortunately inherited Neotel. So they not only inherited the liability, they have to come and talk to us about the criminality that would have been done by Neotel. But if there were any allegations of criminality in any of the matters we are currently dealing with, which in this instance is Neotel/Liquid Telecoms in the Transnet sphere, Chair, we would most certainly look at those. No one is an exception to the rule, even if you are talking to a party. I hope, Honourable Kubeka, that would have dealt with some of the aspects that were raised. Thank you, Chair.
Thank you, Chair. And I'll perhaps just deal with one or two issues that were not dealt with, or just for emphasis. So, Honourable Kubeka, the issue of I think you put it really nicely when you said we must really understand where is the problem coming from. And I think that is critical, because if we don't properly understand the information and the facts, we just, base our opinions on things that are out in the media space. It's very difficult then to properly identify the problem. And so understanding the problem of complex corruption, as you put it, is so critical. And the role of law enforcement in this is hugely important. And I'll deal I'll just emphasize what Advocate Johnson just said about the potential for political interference. Through you, Chair, just to really emphasize that it's not only that our Constitution requires us to do our jobs without fear, favor, or prejudice. As individuals, each one of us here, we took these jobs because we believe in the rule of law. We believe in accountability. We believe in justice. And it doesn't matter who it is. The rule of law means it doesn't matter who it is. If the evidence points to and establishes that someone, on the evidence that we have, is guilty of corruption, of course, or that the probabilities of a successful prosecution are there, we will prosecute. And it is our individual integrity that is so important. But that doesn't mean that all prosecutors in the NPA, in fact, work this way. We certainly, and I will advise you of some of the steps we put in place to try to ensure that, because it's hugely important that we have prosecutors that don't only just mouth without fear, favor, or prejudice, that they actually behave and do their jobs in accordance with the oath that we take. So the understanding complex corruption, I just want to make this one point. As law enforcement and prosecuting authorities, we have a huge role in the country being confident that we are addressing corruption. And we've dealt with a number of challenges, and I will come to that in a second as well. But unless we understand what is the real cause of corruption in this country, that the lack of systems, processes, ethical leadership and good governance across government entities, whether it's on all the levels of government, that is what causes corruption. And unless we address that, I'm glad that with the OPI, potentially the NACAC has actually, the setting up of this new entity that's going to look at systemic corruption and how to deal with that. I think that will really have, because unless you prevent corruption up front, we in law enforcement can be blamed for it. And I know I do not want to minimize how important it is that we do hold people accountable, that the people see that those responsible for corruption are being held accountable. But unless we see it as law enforcement is part of a much bigger strategy in terms of our national anti-corruption strategy to deal with corruption, we will never be able to prosecute ourselves out of the problem of corruption unless we have preventative measures up front. So, and to give the assurance that, I think Andrea's dealt with that political interference. I have not had the executive in any way attempting to influence the prosecuting authority to deal with cases or not to deal with cases. With regard to cases against the poor, I want to say to Honorable Kubeka, there's one thing that I take from Vusi Pikoli, the previous national director, and he always said, always have a bias for the poor. And that is what we want to, as prosecutors, we want to make sure that we are there to help the poor, the vulnerable, the marginalized in communities more than the rich and the powerful who can influence. So that is what we really want to do, is to serve the victims across society, no matter where they come from. You're right, Honorable Kubeka, that the NPA has taken a knock in terms of confidence of people in its ability to do its work. And I'm hoping that I'll just hold with that. But the reasons for this, and you mentioned a number of the cases, Pala Pala, Koko, Omotoso, Bushiri, Estina, Asbestos, Gupta, Choloto, and the Sendiso Makaka cases. And I'll leave the last one for our colleagues in the NPS to deal with. But I want to implore, and the reason why I say this, I want to implore the committee and the people of the country not to judge the success or failure of the NPA on these very important cases. And I'll go through each one of them and I can explain where they are in a legal process so that we can understand what happens. And the danger of coming to conclusions before legal processes was so clearly demonstrated in the New Lane matter, which was the first case, that state capture case, that the NPA, in inverted commas, lost. And we were absolutely, from the national director to the prosecutor, we were denigrated, I think is the word, in that matter. Many of you would have seen the Amabungane documentary, where the national director and many prosecutors, that is the best word to use. New Lane was the linchpin that were used to lynch us. And it caused huge damage to the NPA. And what's happened now is Supreme Court of Appeal has completely overturned that decision. We believed in the case, we believed in the prosecutors, we appealed that case. And the Supreme Court has seriously criticized the judge in that matter in terms of how the matter was approached. And now what do we have to do is retrial before a new judge. And that disadvantages witnesses who have testified, who have to testify again, and there's a whole lot of challenges with the retrial. But we have to deal with that and go through that process. The point I make is that let's allow legal processes before we decide on success or failure of the NPA without allowing these processes to unfold. Advocate Johnson's dealt with the Koko matter, the Omotoso matter. The NPA is doing such incredible work on sexual and gender-based violence cases. This one case, a hugely important case, has really set us back. And I dealt with that, and I don't want to go into any details because when I answered, I think it was Honorable Trollope earlier on, I dealt with that. But this is a matter that is on appeal. The Estina matter, Advocate Johnson is...
Sorry, may I interrupt you? So, when you explained what's going on with the case, I then also thought, well, we hurriedly deported the guy. So now I'm thinking, okay, so we're not going to get him back now?
Chair, this was...
So, and I'm not blaming you, I'm just now wanting to understand how that... I mean, the speed with which he was ejected made a lot of people happy, but now it's clear that he's gone.
Chair, let me say, it's a no-win situation. And I want to just emphasize that, yes, he's no longer in the country. We are appealing that matter, right? So an appeal process can take years. And so, it's, as I said, it's a no-win situation because he could have still been in South Africa, enjoying his life in South Africa, while the victims feel that they've been denied justice and the person they feel is responsible for their pain is still here enjoying life in South Africa, doing things that he wants to in South Africa. The fact that he's had to flee from South Africa means he's not been able to live his life the way he would like to. In the meantime, the appeal process could take years. Nigeria is a country that we do have an extradition treaty with, and there are also other multilateral treaties that we can draw on to hopefully bring him back when we do. We have been successful with many, many extradition applications across the world. The UAE is the one that sticks out, and we've had challenges with that. But generally, we are reasonably successful with extraditing people from other parts of the world. So hopefully the Nigerian government will be amenable, and we'll be able to bring him back to face trial once if we are successful in the appeal process, because that is also, we've got to wait to see what the outcome of that will be. Chair, so the point I make is we can deal with all of these cases where the NPA has been seriously criticized for. And I want to say the following, and the only reason why I say it is because it's important for people to understand what exactly the NPA is doing and why people should not lose faith in the institution. Firstly, our performance over the past 4 years has increased from 50% to close to 75 to 80%. Secondly, the asset forfeiture unit, the freezing orders, which Advocate Rabaji Rastaba explained, and the final orders. If one looks at all of these orders from the inception of the asset forfeiture unit until now, between 45 and 48% of all of those have been obtained in the last 4 years, which gives you an indication of how extremely well the asset forfeiture unit is doing in this space. We can look at sexual and gender-based violence. The Tutuzela care centers, which is a world-class best practice, where victims on their road to becoming survivors get the best support services, in fact, compared internationally. And so conviction rates in respect of those matters have gone up from about 60% to about 75%. So I can go on in terms of all of the good work. And the only reason why I say this is because I want victims of sexual and gender-based violence to know that they must speak out and they must come forward and they will get the best services. And so those are, to deal with the confidence issue that Honorable Kubeka raised, I think it's important for me to show that these are the things that we are doing in order to ensure that the victims get justice in South Africa. With regard to, Advocate Johnson dealt with security of investigations that are outsourced, and so did my colleagues from the DPCI. But I want to emphasize the problem with security vetting in this country. It's so easy to say, have people been vetted? But I want to ask, how many % of crime intelligence people are not vetted? How many percentage of state security people don't have top secret clearance? We must ask these questions. And I think that the answer might be worrying. But let's ask these questions, let's get the facts. And those are people that in themselves must vet institutions in our space. It's a bit, so I think we need to understand, but I do not want to detract from the criticality of security vetting and the ability of the state to do it fast. We have prioritized, we've been working with SSA. I want to hasten to add, we've prioritized, we've given them key people that we would like to be vetted quickly for various reasons, and we've been getting good levels of cooperation and success from SSA. But across government, this is a huge problem. So security clearance, and just to say that many of the people that we work with do not have access to top security documents. It's only, for example, the investigators in the SSA matter that Advocate Johnson spoke about that are accessing top security documents that need the top security level clearance. Otherwise, it's not required. Confidentiality is sufficient level of clearance for people to be able to do their work. With regard to I think for now, let me finish. So Honorable Kubeka raised one other question about staff complement. Just to say that in the NPA, when I took office, we had a vacancy rate of about, in the specialized units that needed to deal with corruption and That's the SCCU, Specialized Commercial Crime Unit, and Asset Forfeiture Unit. We were sitting at around 25 to 28% vacancy rate. But we went on a very aggressive, well, firstly, budget advocacy, because we needed the money. And there were questions around budget, which I will deal with now as well. And we did get the money that we needed from government. So there's been commitment to support the NPA. And we have been on a very aggressive recruitment. We started the aspirant prosecutor training program, which is those straight out of university come through and go through our aspirant training course. And that had been stopped in around 2016. We started that again. And so we bring in students from university, we train them, and they become prosecutors. And now our vacancy rate in the NPA is sitting at around 10%, which is quite acceptable. And so I want to say that we have really been, and your other question was, how do we deal with the competitive remuneration skills? What have we done as the NPA? We've actually done a job evaluation already. We've submitted it to the minister. And there will, of course, have to be engagements after that with potentially, well, with Treasury, DPSA. But that process we've already started to make sure that we can hire those skills at the right salary level, so we can also retain them. At this point, I'm going to hand over to Advocate Mzinyati and Advocate Kanyana to deal with some of the NPS issues, and I don't know if there's some asset forfeiture issues, and then I'll come back to matters that are still outstanding. Thank you, Chair. May I, through you, Chair, of course, Advocate Mzinyati.